Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss Schedule 10 of the Constitution of India and also whether the Speaker of the Legislative Assembly has got power to take away the ex-MLA status of any MLA. See, very important decision. Whether the Speaker can take away the ex-MLA status of an MLA. So, Supreme Court decided the matter. You can refer the case as Gyanendra Kumar Singh, Gyanendra, G-Y-A they have written, Gyanendra Kumar Singh and others, and three others actually, versus Bihar Legislative Assembly Patna and others in Civil Appeal number 5463 and 5464 by 2015, which was decided on 29/9/2022. Right. Honorable CJI, Chief Justice of India, Sri U. Lalit, bench consisting of CJI, Justice Rabindra Bhatt and Justice J.P. Pardiwala, held that in their view, Speaker was not within his jurisdiction to issue direction other than the so-called disqualification. They have set aside the order of the Speaker. So what happened? Better to know the previous instance. You know, these four MLAs by names, they are belonging to JDU, Janata Dal U, Nitish Kumar batch. So JDU MLAs, Gyanendra Kumar Singh, Rabindra Raj, Nawaz Kumar Singh, Neeraj Kumar Singh, and Rahul Kumar. So they were declared to be disqualified by the Speaker on 11/11/2014. The Speaker of Bihar Legislative Assembly, Uday Narayan Chaudhary, he has issued the orders. So here, the important point to note is that Schedule 10 of the Constitution of India is otherwise called as the Disqualification Act. It is an act intended to disqualify the MLAs who change the parties. So he gets elected in the name of one party, then he will change to the other party. So it is amount. So if the Speaker is satisfied, actually the ball is within the court of the Speaker. If he is satisfied, he can declare him as disqualified. Schedule 10 gives enormous powers. You all know that there is no time limitation for the Speaker. Suppose if an application for disqualification has been filed before the Speaker, till the end of his period, that is till 5 years, he can sleep over the file and we can't do anything. That is the main problem. Actually, late Rajiv Gandhi, his intention to include Schedule 10 about the disqualification is to cut aside the Ayaram Gayaram culture. At the time it was too much in 1990 so he wanted to cut short the same. Therefore, he brought the so-called anti-defection law, or we call the disqualification law, wherein the powers are vested with only the Speaker. Courts have nothing to do in this. Only thing is, court can go for the so-called judicial review. That's all. Enormous powers were given to the Speaker. In this particular instance, the Speaker has actually disqualified the MLAs. At the same time, he also deprived them of their previous benefits and pension because he has disrobed them of the formal MLA status also. This is the main crux of the issue. Now, please remember, the Honorable Supreme Court of India, they say, yes, Speaker has got powers. Only powers of disqualification or not. That's all. He has to decide whether this MLA is disqualified, if so, for what period. That's all. He has no authority to disqualify the earlier status also. But the Speaker was under the impression that since they have been disqualified, they will be so-called, they will not get any pension, other benefits. Like that, the order was written, which is not correct. Now the Supreme Court clarified that the power of the Speaker is only to decide whether qualified or disqualified, disrobing them of their previous status as ex-MLA and stopping their pension and other benefits is not within the hands of the Speaker. So now it is clear that the powers of the Speaker are limited only up to the qualification or disqualification. That's all. Not, he should not delve deep into the matter. This is what is stated by the Honorable Supreme Court of India. Good judgment. Please read it and enrich your legal knowledge. Thank you.